Mr. Greenwade.
Yes, sir.
How's jail?
I had
Buckle up. This courtroom just turned into a battleground of second chances, broken promises, and no-nonsense justice. Today, we dive headfirst into a double DWI disaster, a defendant who swears he's changed, and a judge who's heard it all before, and she is not buying the bunny in the woods routine. Meet Mr. Greenwade, an offshore engineer with a past he claims he's left behind. But the court sees 13 FTAs, bond forfeitures, false IDs, and more red flags than a NASCAR race. Can a man truly change? Or is this just another slick courtroom performance? Then enter Mr. Wright, a man battling drug addiction, caught violating bond conditions, begging for one final shot, but with a history of rehab attempts and a rap sheet that rivals his promises. Will the judge finally break and give him a shot at redemption? You do not want to miss this. The stakes are sky high, the tension is brutal, and the judge, she delivers one of the most scathing lines we've ever heard on this channel. Let's get into it.
but I put
Apparently
myself
it's good because you're laughing and you're in great spirits.
Sir, I put myself in this predicament, so I gotta.
Well, at least you can recognize that that's a good thing, you know? So you were wanted out of Orange County for a DWI,
Yes, sir.
and now you've picked up another DWI here in Harris County. Your lawyer,
Apart.
I'm sorry?
They're about 5 years apart. But I know.
So you've been gone for 5 years,
Look,
and you want me to set you a bond?
sir.
So you here because you're wanted out of Orange County. You're now being here held in Harris County at 0 bond. So we have you here out because your lawyer is asking me to set you a bond.
Yes, sir.
Because otherwise what happens is you sit here in custody until all of your cases
Here's
are
where
done
things
here.
get legally
And then we
interesting.
wait for
The
Orange
judge
County
makes it crystal
to
clear
come
she is
bring
not
their
just looking at
happy
Greenwade's
selves
courtroom
over
charm.
here to
She is
pick you up.
focused on the paper trail. The real question is not, are you sorry? It is, are you a danger to the public? This is a classic judicial balancing act. Judges can set a bond even for fugitives, but only if they believe 2 things: the person is not a threat, and they will show up for court. And let's be honest, with a track record that includes DUIs, a bond forfeiture, false ID, and 13 failures to appear, this defendant is testing every ounce of leniency the court could offer. This is not just about one mistake. This is a pattern. So ask yourself, if you were on that bench, would you let him out?
Yes, sir.
A lot of times, me as a judge will set a bond on a fugitive case if I feel that the person is not a danger to the public, because that's my main concern. 2, are you a danger to the public? Number 1. And number 2, if we set you a bond, are you actually going to go to the jurisdiction that wants you? Therein lies the rub. That's the question for you. But I know that what you're going to tell me now, it's like little bunnies jumping in the woods. Yeah, right.
No.
But it's what's on paper to me that matters, because what's on paper is the person who you truly are. Mr. Kim, tell me about Mr.
The warrant from Orange County was issued out on January 2023. Between that time and being apprehended today, he was again charged, or he was charged with DWI on October 2023, in which he bond forfeited 2 months later and was apprehended again when he was simultaneously charged for failure to ID, giving false information.
Is that here or over there?
Here. So he had a DWI or DUI in Orange County. While after that warrant was issued, then he picked up a DUI here, and then he bond forfeited the Harris County DUI, and then he was picked up 5 months later and was also charged with failing ID by giving false information, and then obviously bond violating the DUI. I've shared with counsel in other states he has a failure to appear at least 13 times and evading.
Oh,
I believe he's the definition of a flight risk.
At this point, Mr. Greenwade's past comes back like a tidal wave. 133 failures to appear. That is not just a bad track record. That is a masterclass in evasion. Even worse, he failed to appear after bonding out on a second DWI and gave false information to law enforcement. That is a felony in many states and a huge red flag when someone is asking for trust. The defense tries to paint this as youthful mistakes, but the prosecution frames it perfectly. This is a textbook case of what judges call APO, absconding, playing the system and outrunning responsibility. This moment highlights why the court has to weigh public safety over personal pleas. Do you think the judge should look past all this and give him a bond?
Sir, I was young. That was years ago.
How old are you now?
I'm 28. I'm an engineer offshore. I got my ducks in a row. The DWI here, it was a miscommunication, and I showed up in court to the lawyer after I failed. She said I failed to appear. Me and my lawyer showed up in court and explained that it was a miscommunication. She reinstated the bond. We're back on good terms with everything. I think I have a court date coming up soon for that. My lawyer, she said I no longer have to show up since I work offshore, so my lawyer's gonna show up for me. So this is the only thing that I have. Those other cases, when I was a young college student, I got my stuff together now, Judge. I promise you, like, I am not a flight risk or anything like that. I take my life very serious, and I'm not just talking. I'm speaking from the heart.
Little bunnies jumping in the
No,
woods.
sir, definitely not.
Now this is where courtroom theater kicks in. Green Wade tries to flip the narrative. He's got a job offshore, a supportive mom, and swears this was all just a miscommunication. But here is the rub. He did not just miss court once. He bonded out, failed to appear again, and then got picked up with false ID. That is not miscommunication. That is manipulation. And while he sounds sincere, speaking from the heart, as he says, the judge is clearly not swayed. When someone's history shows a pattern of avoiding accountability, emotional appeals start to lose their impact. That line from the judge, "Not even Jesus himself could convince me to give you a chance." Brutal. But this is exactly why so many viewers love courtroom drama. It is raw, real, and unapologetically honest. Would you believe him?
Most definitely not. And if I am able to bond out, I will
Let me ask you
show up
this.
in Orange
If
County.
you were the judge, would you give that person standing in front of you a bond?
Yes, sir. I would love for you to. I'm going to show up out there. I've already talked to my mom and everybody. I'm showing up. If you give me a chance, or I promise you, I will not disappoint you.
Not even Jesus himself could convince me to give you a chance now, Mr. Greenwade. 13 FTAs.
Sir, those were a decade ago. I was young.
Still
I'm
28,
a
Mr.
whole
Greenwade.
different man. I'm a whole different person. I've been through college, put myself through. I'm on my stuff, sir. I've been at my job.
So the fact that you took off on the DWI here, not 5 months ago, you've matured since that 5 months, I guess.
That was just a miscommunication, and I took it upon myself to show up in court. I showed up in court myself. I did not run. I was not caught. I showed up in court myself. Told the judge about the miscommunication. She took the warrant off of me. I did not run.
It is worth noting that the last evading and the last failure to appear is 5 years ago.
Years ago, sir. I've been on a straight line, and I'm trying to stay on it.
Okay, I'm gonna make sure that you're gonna keep this straight line too.
This is not just a denial. This is a lesson in consequences. The judge refuses to enable what she sees as an ongoing pattern of reckless behavior, and she is not wrong. 2 DWIs in separate counties, bond violations, and a history of failing to appear. That is not bad luck. That is dangerous. Green Wade argues they are years apart, but 5 months between bond forfeiture and rearrest tells a different story. The court is not here to comfort defendants. It is here to protect the public. And enabling someone who repeatedly breaks court conditions sends the wrong message, not just to the defendant, but to every single person watching. So the judge shuts it down, not with anger, but with firm, principled logic. This moment is not just courtroom drama. It is a reality check.
I don't think so, Mr. Greenwade. I'm sorry, but
Judge, would you at least consider a high fee, 5,000, put some skin in the game and,
from me, from Mr. Greenwade, if I were to set something, it's probably going to be like 150,000, because that way, I just, you know what? I don't even want to do that because I don't think you're going to show up.
Sir, I'm going to show up. I'm going to lose my job behind this. I've been working so hard, to get everything together. I'm going to lose my job and everything. I'm going to lose everything. And I've been doing so good. I wait for that to happen.
And me, you know, and I don't want that to happen to Mr. Greenway, but at some point you got to get it. And for me, if I were to give you a bond now, I would be enabling your behavior. And I would say, yeah, it's okay for you to do this when it most certainly is not, especially in light that you have a DWI over there. You've got now a DWI here. It's as bad as it gets, man.
They're years apart. It's not like I'm just out here repeatedly getting in trouble. I'm working, I'm handling my business.
Okay.
Thank you, Judge.
Thanks.
I'm approaching
Thanks, Judge.
Miller just because.
So keep it in.
Is this the one where you took over from the other?
Your box, if I would be quiet.
How's jail? How's jail? Good. I hope it's an absolutely miserable experience because we're not getting through to you. What do we need to do to get through to you that you have to follow bond conditions? You now have picked up a new case while you're on bond for a felony. You now stand charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, Mr. Wright. Please.
Unfortunately, 5/2024 traffic stop for expired registration in Harris County, Texas. Driver Pittman gave consent to search the vehicle. Affiant had defendant Wright stepped out of the vehicle and got consent to search his person. Officer conducted a Terry first and felt his waistband and pocket. Officer then felt objects that could be narcotics related and searched his person and found pins. Officer located backpack with 1.1 grams of marijuana in the passenger seat.
Okay. Mr. Wright, I'm going to find that there's probable cause. Let me ask you, do you have a valid Texas driver license?
Just a moment.
There's another violation. You don't get it. Mr. Wright, you will sign an affidavit with me promising me you're not going to drive. There's no faster way for you to get a lengthy jail sentence than you get in a car and drive. If you ever get in a car and drive without a Texas driver license and liability insurance in violation of this affidavit, you'll be facing 6 months in jail and a $500 fine every time. And I don't care if Mother Teresa needs a ride to church. You get in a car and drive, you'll be doing 6 months every single time.
Now we pivot to a second case, and this one turns into a lecture on reckless endangerment. Mr. Wright is caught driving without a license while already on bond for a felony. And what does the judge do? She draws a legal line in the sand. The courtroom falls silent as she lays it out. Every single time he gets behind the wheel, it could cost him 6 months in jail and $500. Even if he is driving Mother Teresa to church. The lesson here, court orders are not suggestions. They are binding legal conditions. This is where we see how compassion meets consequence. The judge wants to believe in rehabilitation, but not at the cost of public safety. So now Wright faces a choice. Follow every rule to the letter or go back behind bars. What would you do in his place?
You understand? Why on earth would we give you a PR bond when you continue to violate conditions? Why should we give you a PR bond, Mr. Wright? Tell me. Because Lori is asking me to let you out. But if I let you out, what are you going to get? Pick up a third case? Tell me why.
Needles for about 2 years now. I think if I go back to it, I'm going to die. Let's go to rehab. Literally, let's go to rehab. I'm trying to go to the wheelhouse.
Every person I meet here is about to do this. They're about to do that. Intentions are great. It's actions what count. Your intentions go in one ear and they go out that ear. That's how good intentions are. So maybe we should keep you in custody and put you in a rehab then.
I tried going to the Texas house. The last one I got rehab to, the one I got sent to before rehab was the Texas house. That was a year-long program. Had a really short, really low percentage of graduating. I made 6 months the first time and 10 months the second time. I got scared. I went back to where I came from. Last, I don't want to go back to. I just want to. I already know there's a really good record at the Bill House over there on Deer Park, right down the street from the police department. I have a friend of mine that just went through it. He's going through. He's had these same issues as me, as far as drugs are concerned.
You're not giving me much confidence, Mr. Wright.
I want to get past this.
I don't think that you can do it on your own. You've already shown us that you cannot. Tell me again, why would we let you out? What do you think?
Give him a chance. He makes it, he won't get another chance.
The only way you will get a chance from me, Mr. Wright, is if you come here 2 times a week and take tests showing me that you're not using anything, and you go to AA or NA 3 times a week with proof that you're doing it. I will give you a curfew of 9 p.m. and you must maintain a full-time job. If you want me to let you out, those are the things that you must do. And you must take an active part in sobriety. 3 times a week, I want you to bring me proof that you're going and doing NA classes. A piece of paper, that date, name, sponsor, and where you had the location and where you went to go do it. But I want proof every other day that you are going to NA classes, and you will take drug tests 2 times a week to prove to me that you're not consuming anything.
Just when you think all hope is lost, the judge surprises us. She offers a structured, hard-earned path to freedom for Mr. Wright. Drug tests twice a week, NA or AA 3 times a week, a full-time job, a curfew, and 0 tolerance for any violations. This is what restorative justice looks like. Not just punishment, but a chance to prove change through action. The catch? It is not easy, it is not comfortable, and it requires total commitment. She even spells out the consequence: fail once, and it is jail, rehab, and a 9-month minimum stay. This is the courtroom version of last chance, but here is the kicker. She has never given him a chance before. This is his one and only. This moment is powerful. It shows that judges are not heartless. They are just done with empty words. Now we ask you, will he follow through, or will history repeat?
This is the only way that I will let you out. And if you know that you can't do it, don't. Because if you muck this thing up again, because what I'm going to do here is I'm going to put no driving, and right under it, I'm going to put no drugs and no alcohol. And if you violate this, I will hold you in contempt, slap you with 180 days in jail. I will probate it for 2 years. I will put you in jail and then put you into a treatment facility in the jail where, if you're good, it's a minimum of 9 months, depending on how well you respond to treatment. So if you violate this thing, you will go into a treatment facility for a minimum of 9 months.
Yeah.
You understand me? Okay, Mr. Wright, you know what's expected of you. No driving, no alcohol, drugs, NA, 1 AA 3 times per week. Okay, Lori, I'm gonna grant it to you. However, he knows what's expected. Mr. Wright, let's see. You will never get another chance. This is the only chance because I've not given you one. That's the only reason. I believe everyone should get at least one chance. This is the only one, and I'm gonna keep you so close to me, you're gonna think that you understand. All right. Deputy, do you mind bringing him over here so he can swear this to this, and then you can put him back?
Just trying to raise your.
All right. Hey, Hugh, come on up.
2 men, 2 stories, 1 courtroom. Mr. Green Wade, with a long history of failures to appear, tried to plead maturity and change, but the judge saw through the performance. With public safety at risk, she denied bond, drawing a hard line between remorse and responsibility. Mr. Wright, meanwhile, stood at a similar crossroads, but his willingness to submit to intense supervision and treatment earned him one final shot. Strict drug testing, rehab attendance, and employment will now decide his future. This case reminds us, redemption is possible, but it comes with accountability. The courtroom does not reward promises, it rewards proof. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. Your voice matters. Would you have made the same rulings?